The majority of individuals who will watch this video are governed by laws. Most of the laws that govern these lives, they are not even aware of where they come from, where the duties and the obligations come from. What transpires here in Canada is that you are changed from the designation of human being into the role that you are about to play. So, for example, if I, as a human being, am going to travel in my vehicle, they change my designation from that of human being and then render me under the status or designation of driver. So I'm considered a driver. When the police officer will pull me over, he won't say, you are a human being in a vehicle. He will say you are a driver operating a motor vehicle. For example, now, if you are going to be out there working and pursuing or earning and gaining a living, and then you are considered a taxpayer. Your designation from human being is changed, and now in law you are recognized or designated under law as a taxpayer. If you are out there, for example, as a human being, again, and you're earning or pursuing after a living, then your designation now is considered a worker. You are designated under law a worker. If you own a piece of property, for example, where you live, you're considered a homeowner under law. So what's necessary to notice here is that your capacity, your designation is changing depending upon what role these enactments, these government-created laws, want you to play. Now, each one of these designations, when you step into that role or take that designation of worker, taxpayer, and so forth, each one of these roles are given, or it is recognized that they have different rights, duties, and privileges. And the rights or duties that are charged to this capacity are brought forth through enactments, through government-created laws. So, for example, if I'm a homeowner and I'm living in a municipality, I cannot go and take a horse and bring that horse onto my front lawn in the middle of the city and have my horse live there. The municipality will come by and they will say, excuse me, you have to remove that horse from your front lawn because for public good, we're administrating this property and you cannot keep a horse on your front lawn. They will claim to have a government enactment and they will say that you as a homeowner are charged with the responsibility to follow this law, this regulation. So you're standing in the capacity as homeowner and they're saying the law affords me the right to say this is your obligations under the law. Again, for example, if you're a worker, if you're going to go out and work in a construction area, well, the law says that a worker, when he works in a construction area, must have safety gear. You must have a hard hat on your head. You must have construction boots upon your feet, and so forth. If you were to go out and work in that condition and not have that safety gear, you can suffer consequences to those actions. So the worker is charged with the duties and the responsibility to say, if you're out there, you must be wearing safety gear. So what we're looking at here is that whenever you take another designation besides that of a human being, the rights and the duties and the privileges that are charged into that designation stem from government-created laws, government enactments. Now, there are two types of law that are important to us here in Canada, or basically in any nation across the world, but I'm living here in Canada, so I'm speaking more specifically about Canada. The two types of law are one, as we have spoken, enactments and regulations, and the second is called natural law and natural rights. So as you see, this type of law, natural law, is thought to exist independent of the government. The rights that attach to the human being because of who they are just naturally do not exist because the government create them. Presently, in 2014, the government has the obligation to recognize them. Nevertheless, they did not create them. These rights and freedoms are fundamental rights. They exist apart and independently from the government. So when I remain in my capacity under my designation of who I truly am, that being a man or a woman, a human being, the plural of that, I have natural rights that are mine, that are charged within me, that are recognized within me because of who I am. And these rights are inalienable to my nature, which means that they can never be transferred and I can never surrender them. And these rights are absolute. They belong to me because I'm human. I'm a human being. And those are the two different branches of law that are transpiring that we need to be aware of here in Canada. We have enactments, government-created regulations, and we have natural rights through natural law. And these rights are inalienable to my nature, and they are absolute to my nature. Here in Canada, you are not taught your fundamental human rights and freedoms. So far, we have seen in law that there is natural law, which produces natural rights. These rights are inalienable and absolute. They cannot be surrendered, and they belong to every human being. These rights are better known as fundamental human rights and freedoms. Now, within law, we also have enacted law, statutes, and regulations. These are laws that are created by the government. These laws are not natural rights, and these are meant to be used as a controlling mechanism against the people or for the people. These laws are created by government and enforced by the government. So a few examples of these laws would be taxation, property tax, only driving as fast as their sign tells you on the side of the road. If you want to fish or hunt, you have to buy a permit. The Canadian National Building Code. The list could go on and on. These are types of laws that are created by government. Now, most of us have these created laws governing us and controlling us. We may be aware of some of them, but there are so many created laws from the government, it would be next to impossible to know them all. The next question logically would be, well, who do these enactments, these regulations, these statutes apply against? Do they apply against me as a human being, or do they apply against another designation? We've learned that, okay, I know if I take a worker, so that's applying against a worker. I know if I take the designation of taxpayer, it applies against the taxpayer. Now, is this the operation of law that we are seeing in Canada, that the enactments apply only if you take that designation, or is there some other type of mechanism that is in operation here? Well, when we look into the Canadian Citizenship Act, that's the enactment where everyone takes the pledge to become a Canadian citizen. Now, most of us who are born and raised in Canada, we've never actually taken that pledge. We've never taken the oath. It is, though, deemed in law that we have tacitly accepted to take that designation, to assume that role, and to say that we have given ourselves to this oath. And the oath reads as follows. It says, I swear or affirm that I will be faithful and bear true allegiance to Her Majesty Queen Elizabeth II, Queen of Canada, her heirs and successors, and that I will faithfully observe the laws of Canada and fulfill my duties as a Canadian citizen. Now, if you listen to that oath and the pledge step by step, you see that this is the binding mechanism. This is where it starts. Because allegiance is a citizen's or subject's obligation of fidelity and obedience to the sovereign. So whatever the sovereign says, I must do. I pledged my allegiance to you, sovereign. I gave you my allegiance. Therefore, what you ask of me, what you demand of me, I will do. Now, a subject in law is one who owes allegiance to a sovereign. And law says, and is governed by the sovereign's law. So, whichever sovereign is governing your territory, here in Canada, we have Queen Elizabeth II. It is her who is sovereign in this territory. We have pledged allegiance to her, and we have promised to obey her laws and her rules. Now, when you look into the Constitution Act of Canada, 1867, you see that it is clearly indicated that it is the executive powers remain vested in the Queen, in the office of the Queen. And then we further see that the Queen transfers her executive powers into the Governor General of Canada. And he subsequently shares this power with the lieutenant governors of each province. Nevertheless, the article of law in the Constitution Act of Canada, 1867, Article 10, states that the Governor General is acting on behalf and for the Queen. So the Constitution Act of Canada is very clear. It states that Her Majesty is vested with the executive powers, or is the ruling power of Canada, and she has given her power, or allowed her power to be operated by the Governor General on and for her. Now, these enacted laws, these created laws, when we look into them, we see that before they are given power in Canada, before they are given royal assent in Canada, they will find a statement that is indicated in there, which says, therefore, Her Majesty, now, with the advice and consent of the Senate, enacts as follows. So that it is actually Her Majesty that is enacting these laws, and these laws apply upon her subjects. Now, through that oath of citizenship, remember, you said, I promise to obey the laws. I pledge allegiance to the Queen. Now we see her enacting these laws through the enactments, giving it force of law, and applying it upon her subject who owed allegiance and who promised to obey those laws. Now through that oath, you invite punishment upon yourself for not fulfilling your duties as a Canadian citizen. As a Canadian citizen, you took an oath. You have duties and obligations to fulfill. Part of those duties and obligations are you must obey the laws that the sovereign, Her Majesty, puts into practice, puts into operation upon this land. The enactments, the regulations are given royal assent, and you are now placed into a position of duty to these enactments, and you must follow them. And if her agents of law come by and you are not fulfilling your obligation to these enactments, they can seek to penalize you. This is the operation of law that is transpiring here in Canada. However, that is all on one side of the law. There's still the other side, remember, of our natural rights. These rights that we have that belong to us, well, how do they conflict? How do they operate with what is transpiring here? looking into the Constitution Act of Canada 1867, Article 91. Listen to what it says. It shall be lawful for the Queen. You hear it? It shall be lawful for the Queen, by and with the advice and consent of the Senate and House of Commons, to make laws for the peace, order, and good government of Canada. Now, concerning currency and coinage, banking, incorporation of banks, and the issue of paper money, and concerning the raising of money by any mode or system of taxation. Now, this is just a few examples. So we are seeing here that it is lawful for the Queen to make laws. And we understand that these laws, she gives them royal assent. And these laws apply upon her subjects and her servants. And they must obey, it is their duty to obey these laws. And again, that is the position, that is our designation under law. That is a situation that is transpiring against us. Talking about our fundamental rights and freedoms, natural rights, natural freedoms. When you look into the definition within black laws, within the legal language that's transpiring all around us, it describes it as a right derived from natural or fundamental law. And it's constitutional law. So fundamental law is expressed in constitutional law. That means our natural rights, our inalienable rights, are expressed within constitutional law. Somewhere within them, they must be expressed within constitutional law. Again, as you're seeing, when we look into black laws, it says organic law. Now watch, the body of laws as in a constitution that define and establish a government. And then they quote fundamental law. So it's very clear here that when they talk about organic law, natural rights, they talk about the fact that it's fundamental rights, fundamental law, and it has to be established within the constitution of a government. And this is just basically in black laws. This is not something that's like a binding to a country or anything. It's just basic law dictionary. But why is this coming out? Why, when we look into this law, why do we find this coming out? As we are seeing, we have natural rights, fundamental rights, and these rights are inalienable, and they come out through the expression of constitution acts of the countries. Now, when we look into the International Covenant on Civil and Political Rights, Article 8.2, this is a specific right that is recognized. It wasn't created by the governments. It wasn't created by the international bodies. It was recognized as a natural right that a human being has. And Article 8.2 of the Covenant states, no one shall be held in servitude. So this is a fundamental right, a fundamental human right from natural law that is expressed in an international covenant. Now this international covenant, in case you haven't watched any of my videos, and this would be your first video that you're watching, this international covenant is a binding covenant upon Canada. In 1976, Canada signed upon this covenant as a signatory to it. And all the obligations, everything that was brought forth within the international covenant, Canada had to fulfill. And I'm going to share with you a little bit of the obligations that Canada had. But I wanted to show you first and foremost that me and you, as one individual human being, one individual man or woman, in law, there's a recognized right that says no one shall be held in servitude. Now, if we flip that around and apply it to what we've learned up to this point in this video, this is against the citizenship of Canada, because we are being forced, tacitly or expressively, to take an oath of allegiance to a sovereign, and to be placed into a position of subject and servant to be placed into position of servitude. And this is against the natural right of a human being. In 1976, Canada became a signatory to the international covenants, and the obligations that were present in the international covenants, Canada had to express them. And here is one of the obligations that Canada fell under, i.e., Her Majesty fell under. It states in Article 2.2, were not already provided for by existing legislative or other measures, each state party to the present covenant undertakes to take the necessary steps in accordance with its constitutional process and with the provisions of the present covenant to adopt such laws or other measures as may be necessary to give effect to the rights recognized in the present covenant. So Canada became obligated to express all these rights and freedoms, whether they were for the human being or that citizen, that artificial player. They had to express all the rights and freedoms within the constitutional process, meaning the Constitution Act of Canada, or by other measures. Nevertheless, the obligation remained upon Canada, and Canada had to give effect to the rights that were recognized in the present covenant. So whatever rights and freedoms were recognized in the covenant, Canada must transfer them over into domestic law, either through the Constitution Act of Canada or through other measures. And if the state party Canada refused to do that, they would be in dishonor of their obligation as being signatory to the International Covenant. That is why, in 1982, there was a new Constitution Act of Canada that was brought forth. That was titled or designated the Charter of Rights and Freedoms. Now remember, I just shared with you that one of the natural rights, natural freedoms that is recognized in these covenants is that no one shall be held in servitude. So this placed an obligation for Canada to express this within their domestic law. As you see, what you just read, the player in Section 7 who has the right to liberty is a human being. And furthermore, the courts recognize that they are under international obligation to respect these rights. And the courts will strive to respect these rights. Now, furthermore, looking into the International Covenant on Civil and Political Rights, Article 2.1, it states that each state party, meaning Canada, to the present covenant undertakes to respect and to ensure to all individuals, me and you, within its territory and subject to its jurisdiction, the rights recognized in the present covenant. So there again, another obligation. Canada, as a state party to these covenants, must respect and ensure my individual rights. They may not like to have to deal with me as an individual. They like to deal with us as classes of persons. And I'm not going to go into what all that means or signifies tonight, but that's how they like to deal with us. If you're a worker, you're a class of persons. If you're a taxpayer, you're a class of persons. But you're an individual, I'm an individual, one man, one woman. And I'm sharing with you one natural right that is recognized in law, the right not to be held in servitude. And that right, it states here in Article 2.1, Canada must respect and ensure to all individuals this right, because it's recognized in the present covenant. No one shall be held in servitude. Now we look for the corresponding law in the Constitution Act of Canada, 1982, Article 7. It says here, everyone has the right to life, liberty, and security of the person. So everyone has the right to liberty. Liberty is the opposite of servitude. When you look farther and dig deeper into what's transpiring here in Canada, you will find a judgment from the justice system that clearly states that the everyone here, that designation, it doesn't apply, it applies only to a human being. It doesn't apply to an artificial person or to another type of artificial entity. The everyone spoken about here is strictly for the human being, and that human being has the right to liberty. It does not have to be held in servitude. And why is that? Because the International Covenant, which placed the obligation upon Canada, upon Her Majesty, to give effect to these rights, are clearly expressed here. And if Canada didn't express these rights, again, they would be in default of their obligations. So we clearly see it coming out. Now we further learn that the Constitution Act of Canada in Article 52 states that it is the supreme law of Canada. The supreme law of Canada. It is above the enactments. It is above the regulations. It is above those statutes that have been given royal assent and apply against her subject and servant. The Constitution Act of Canada is the supreme law of Canada, and any law that is inconsistent with the provisions of the Constitution is to the extent of the inconsistency of no force or effect. So I have, and my right, my natural right is preserved, not to have to be held in servitude, not to be have to force to play the role of subject and servant of Her Majesty. And if someone tries to come and apply an enactment or regulation against me and force me into servitude to those laws, because they're claiming that I've taken an oath of allegiance and that I've promised to obey those laws, well, they're breaking my natural rights. They're breaking my fundamental human rights and freedoms through that operation, through trying to do that to me. As you can further see, another obligation. No state party, Canada, Her Majesty, no group or person can perform any action aimed at the destruction of any of the rights and freedoms recognized herein, or at their limitation to a greater extent than is provided for in the present covenant. You see, when you read these covenants, international covenants, there is going to be provision for limitation of certain rights. So the covenant will state a certain right, and then it will provide a limitation for that right. But the human rights, our natural rights, our fundamental rights, when you go through the covenant and you read and study the covenant, you will never find, never, ever one time, you will never find a provision for them to remove this right. Because remember, when we talked in the beginning of this video, our natural rights are inalienable. They cannot be transferred, neither can they be surrendered. So when they are expressed within the international covenant, the attribute or the action of that right remains the same. It cannot be transferred, it cannot be surrendered, it cannot be limited by what they call a fundamental principle of justice. So when you are granted, or it is recognized, don't want to say granted, but when it is recognized that you cannot be held in servitude within the international covenant, and that is expressed within domestic law through the Charter of Rights and Freedoms, the Constitution Act of Canada, 1982, Article 7, No one can remove that right from you. Now, look furthermore what it states in the International Covenant on Civil and Political Rights, Article 4. Even in a time of emergency, so when things were going bad, if there's a time of emergency because of war, or if there's a time of emergency because of famine, or if there's a time of emergency because of sickness, then the rights that exist in Article 8.2, among others, in the International Covenant, but we're focusing down on Article 8.2, which is that no one can be held in servitude. That right can never be removed. They can never place a limitation upon that right. And Canada is obligated to follow that operation of law. So when you come into Canadian law, and you come into something that's called an emergency enactment. Now this is an enactment that is created by the government. This is an enactment that is created in case there's an emergency that is happening within Canada. And it says in the Emergencies Act, I'll read preamble, whereas the safety and security of the individual. Now again, if you haven't followed my videos, if this is the first time you've watched my video, you don't understand what they're saying there by individual. They didn't use the word person there. They didn't use the word citizen there. They didn't use the word everyone there. They specifically used the word individual. And a quick lesson to understand that word individual is it has a capacity to break down in two ways. It has a capacity to represent an artificial being that's subject and servant of Her Majesty, and it has a capacity to represent one individual human being. And that's why they must bring that forth, because in a time of emergency there are rights and obligations and duties placed upon the citizen, the artificial person, and there are rights and freedoms that always remain in operation for the human being. That's why they have to use the word individual here specifically. Now when you further read in this enactment, it states the following, and I quote, "And whereas the Governor and Council," now the Governor and Council is the Governor General of Canada, the one who is operating on behalf of Her Majesty, the one who has been given the authority and executive powers from Her Majesty. It says, "And when the Governor and Council, in taking such special temporary measures, would be subjected to the Canadian Charter of Rights and Freedoms." So in a time of emergency, he is subjected to the operations of law that are flowing from the Charter of Rights and Freedoms. And it says, "And he must have regard to the International Covenant on Civil and Political Rights, particularly with the respect to those fundamental rights that are not to be limited or abridged even in a national emergency." So Canada is very aware that we all possess, as individual human beings, certain rights and freedoms that can never be removed from us, that are inalienable to our nature, and even in a time of emergency, they do not have the right to regulate those rights. But what's transpiring is that none of us, or very few of us, understand our rights. In Canada, there was an obligation in the International Covenant. If you go to the International Covenant on Social, Economic, and Cultural Rights, Canada had an obligation first and foremost to teach us all of our fundamental human rights and freedoms. And secondarily, they were to teach us and educate us concerning the capacity as operating as persons before the law.